This is Chapter 17, Part 2 lecture video. Chapter 17, Part 2, we are on Slide 12. Assisting witnesses. Often witnesses and victims feel forgotten. Oh yeah. Parties involved in the case should attempt to reduce inconvenience of testifying, and victims should be kept informed of the trial dates. Witnesses should be spoken to before the trial and highlight possible issues. Memory might be a particular issue. Page 525, third paragraph. It is good police procedure to talk with all witnesses a few days before trial or other court appearances in order to determine what they can recall, their memory. Care must be taken, however, to avoid making comments that can alter their memory or giving them false sense of confidence in the quality of their recollections. Attempts may be made to refresh their memory, but officers may never tell the witness what to say. And same with the prosecutor. Slide 13. Admissions on reports. Witnesses may lack current memory. What they said earlier may be admissible, however. And there's a Federal Rules of Evidence 803 that talks about the exception to hearsay, and that was covered in Chapter 9, so I'm not going to cover that again. Slide 14, appearance issues. Witnesses are often judged by their external appearance. Same with you if you end up testifying in court. How a witness looks can be critical. For a lay witness, for a police witness, for an expert witness. How a witness speaks is important. The content of their speech and their method of speech. Just a quick rundown. For testifying in court, especially if you work in law enforcement, you should have a suit that is neutral colored, no pinstripes, probably avoid red, so it should just be neutral, brown, black, dark green, navy blue, gray. Polished shoes. For women, you should have your hair preferably back. It could be down just as long as it's not big. If you wear makeup, it shouldn't be too much. It should be very professional, and you should not have big jewelry. No facial jewelry. Any tattoos should be covered up. That's pretty much it. And men typically should not wear any jewelry or any earrings or anything either. And that's just the stereotypical suggestion of how to dress. Same for interviewing. Slide 15. The jury's first impression is critical. Police should project a professional image, overall clean, neat, and appropriate. Uniforms are common but not always best, and the reason why is uniforms can be seen as authoritative, and some people are very intimidated by a police uniform. So unless you're on duty, the advice is to wear a suit instead of a police uniform if you can help it. Detectives frequently dress in suits. Avoid bling. That's what I just said. Think conservative. Slide 16. And one more thing. I'm very open to everybody's religious backgrounds. I happen to be a Christian, so I'm proud to wear a cross necklace, but I don't wear a cross necklace in court or in an interview. It's not that because I'm not ashamed of my religion. I'll wear my cross necklace anywhere on the college campus or teaching, and I hope that other people who have other beliefs would feel comfortable wearing symbols of their beliefs. But in court, you don't want to have any type of bias at all. You're trying to just be neutral where you're not going to have any judgment or bias. And so that's just my personal opinion about that. You just want to be very neutral and not give anybody a reason to be prejudiced against you. Slide 16, demeanor. You want to be polite and proper behavior. Do not ever be sarcastic in court. An officer is unbiased and not vindictive. And remember, the opposing counsel is just doing their job. It's not personal. Sometimes it can be heated, but you just don't be sarcastic. Be very respectful. Good grammar, strong vocabulary, project your voice. Don't use a lot of jargon. Definitely don't use radio codes or 10 codes. They're not going to know what you're talking about. Slide 17. Seek to clearly understand questions. Avoid appearing arrogant. Don't talk above the jury. Try to explain things in layman's terms. Don't appear as a professional. Don't appear as a professional witness. I'm not sure what that means. Don't be hostile. Behave off the stand while. Oh yes. Be careful how you behave out in the courtroom hallway. Don't talk about the case either. You could have jurors around listening to you. Slide 18. The prosecution, don't become hostile if they don't openly support the police position. Discuss the case with the prosecution before trial if necessary, if you're working in law enforcement. For the defense, limit the contact with the defense. This is according to the textbook. Generally, filter contact with the defense through prosecution. Remain polite but not overly familiar. Here's my rule of thumb. Anything that any attorney asks you, prosecutor or defense, they could say it on the witness stand. Anything you say to them over the phone, in person, they can bring up on the witness stand, and expect that they would. So just be very matter-of-fact, to the point, and that's all I'm going to say about that. If you need to slow things down while you're on the stand, stop and get a drink of water if things are going too fast, the questioning, and that'll slow things down. Do look at the jury if you're needing to explain something. Do not, I already mentioned, but do not ever talk about the case in the hallway of the courtroom or in the bathroom or on lunch break, because people can hear you, and that can be brought up in the courtroom, whatever you say. Also, be real careful. Law enforcement a lot of times have very sarcastic humor, but when you're in the hallway of the courthouse, people can perceive things wrong if you're very sarcastic, or you just want to be careful what you say. And of course, if there's objection going on, wait for the judge. If the judge overrules the objection, then you would answer the question. If the judge sustains the objection, then you don't answer it. Yeah, then you don't answer the original question. And if you're not sure, you can ask the judge. Slide 19. Witnesses, treat them with courtesy and respect. Keep witnesses informed. Jurors, the only contact you should have with a juror would be at trial while you're testifying in the courtroom. No outside contact. Don't answer any questions they may ask you outside of court, but do be polite. 20, slide 20, press coverage. It's the First Amendment. The First Amendment guarantees freedom of the press. The media does have the right to cover trials unless there's an order for them not to. It is limited if juveniles are involved. I think each state has a lot of varying in that. Pre-trial publicity. It may harm the possibility of a conviction. Loose lips sinks ships. That's what they say in the Navy, right? Loose lips sinks cases too. It's not your job to talk to the media, and you're not allowed to talk to your friends about it either. Gag orders are rare, but they may be used to keep publicity down. Slide 21, most cases, if only a minor interest to the media, there's usually only a minor interest. Follow your department's policy and procedures, but do be professional. Slide 22, Shepard versus Maxwell. Sam Shepard was accused of murdering his wife. There was a massive negative publicity about the case. Some of it is fueled by the prosecution and police. The conviction was overturned because of the carnival atmosphere at trial. At retrial, Shepard was acquitted. I believe this is the same Shepard case. That's a big bloodstain pattern historical case, but I would have to do some research to double check that. That's it for Chapter 17, and that's it for all of our lectures.